methodology/data analysis. He has authored numerous refereed journal articles, book chapters, and numerous other publications. He also participates in many local and national media interviews, sharing his expertise in American politics, campaigns and elections, and constitutional law. Before joining the faculty at Cedarville, Dr. Smith taught at Tulane University and Calvin College. Today, Dr. Smith will be speaking on a historical perspective and faith response, the first lecture in our Beyond Roe v. Wade series. So please join me in welcoming Dr. Mark Smith.
Good afternoon. Thank you for coming. Before we get started, I want to thank a few particular people for helping put together this lecture series, especially Jeff Heyman from the School of Business Administration, Trent Rogers from the School of Biblical and Theological Studies, and of course I'd like to thank Cedarville University Students for Life for their sponsorship as well. I'd like to thank Dr. Janice Saplee, Mark Weinstein, Sarah Gump, and of course Leanne McKay for all the work that she does for these kinds of events. So thank you very much. So this is the beginning of a lecture series, if we want to call it that. There are going to be 3 lectures as of right now. Depending on what happens in the summer, there may be more in the fall. So this is the first one, looking at sort of a historical understanding of Roe v. Wade, and then look at the decision and then some of the outcomes. There's going to be a panel discussion on April 5th that I think picks up a very interesting conversation about the nature of Christian citizenship in times of cultural conflict. Depending on what happens in the summer, we could be looking at a significant series of conflict based on the court's decision. And then on April 18th, there's going to be a panel as well on a critical question, caring for women facing a crisis or unwanted pregnancy. So let's start with some numbers. As the slide says there, this is the U.S. abortion rate as measured by the Guttmacher Institute. This is a pro-choice organization, so we're not cherry-picking data here. This is their data and their understanding. And if you notice, it appears that abortion peaked in the early 1980s, and we've seen a fairly steady decline since then. These numbers look innocent. And they're, as numbers, relatively small. 16, 29, 13. But once you start to understand what the numbers reflect, you don't truly understand the gravity of what we're looking at here. So if we took that methodology and counted American service casualties during World War II, what would that look like? 3.2 Americans killed per 1,000 citizens during World War II. 3.2, again, not a really large number. But the question is, how many groups of thousands are there? What is this number 3.2 masking? Well, in America, involvement in World War II, there are 420,000 people killed. 3.2 is a lot nicer than 420,000. Sometimes raw numbers tell a story. Sometimes they're obscured to hide a story. So if we go back to that fairly innocent number to start off with, in 2017, 3.5 abortions per 1,000 women between the ages of 15 and 44, what does that translate to in raw numbers? 862,000 abortions in 2017. Much bigger number, a much more uncomfortable number. And remember, that number's in decline. So let's think through what the numbers look like holistically. From 1975 to 2012, there were more than 1 million abortions performed in America each year. Let me repeat that. From 1975 to 2012, there were more than 1 million abortions performed each year. Estimates are, as of right now, there have been 60 million abortions performed in the United States since 1973. Just to be very painfully clear, an abortion is a deliberate decision to end a human life. That human life is created in the image of God, and it deserves protection. Instead, we have 60 million brothers and sisters, sons and daughters, athletes, scientists, leaders, workers, friends, church members who just simply have never been born. If there had been no abortion, American population right now would be right at 400 million people. So why are we here? Of course, we're here because the Supreme Court determined ultimately that abortion is a legal constitutional right in 1973 in the court case of Roe v. Wade. The court is now considering a case which could potentially overturn Roe versus Wade. The Dobbs case that's referenced there on the screen has been argued before the court in December. The court's going to hand down a decision, most likely in June, and it could change everything. Then again, it might change nothing, but we need to be ready to talk about it. So it could be that Roe versus Wade gets overturned. What that would look like is difficult to tell. What kind of cultural conflict would ensue is difficult to tell. But my guess is it would be significant. It could be that after the court rules that things will stay the same. That Roe will be upheld, that generally speaking abortion and access to abortion will stay the same, and that we'll just sort of stick with the status quo. But I think reading the court and reading the membership on the court, listening to oral arguments, my guess is this is the least likely outcome. I think we're going to see something happen. The third possibility is that the court will uphold Roe and will maintain the right to an abortion at some level, but also uphold the Mississippi law. The Mississippi law forbids abortion after 15 weeks. So it still allows for abortion very early in the pregnancy, forbids it after 15 weeks. It's possible the court will try to do both. Uphold the Mississippi law, uphold Roe. We will talk about these various outcomes here in just a bit. So here's what I'm going to cover, not all of it in a tremendous amount of detail. Talk just a little bit about history, the history of abortion, mostly focusing on the United States, but a little bit of discussion about other instances as well. And we'll talk about Roe versus Wade, the court decision itself, and then we'll talk about Planned Parenthood versus Casey, which is really the case that the court uses now to make decisions about abortion. Roe is still there, it's still precedent, but it's not the important precedent the court refers to. And then we'll talk about Dobbs and potential outcomes connected to Dobbs. So when we think of the history of abortion, we need to think, I think, first and foremost, that in the ancient world, life was just simply valued differently than the way that we value life. In Greek and Roman culture, the practice of exposure was fairly common. Exposure means taking a recently born infant and exposing them to the elements until they die. Now, before you misunderstand, this isn't the result of a shameful pregnancy where a woman's trying to hide the results. This is the decision by the leader of the family, the father, who's deliberately decided that this child cannot bring value to the family or to the community. Therefore, the child is exposed to the elements. It's a fairly widespread practice in the ancient world, certainly widespread in the Greek and Roman societies. And I think rightfully we should look at it and say it's barbaric. It's barbaric. It's a different perception of life than what we have. It's also true that abortion itself was relatively commonly practiced. and also occasionally punished. So that wording is very deliberate. Commonly practiced, occasionally punished. So in what circumstances could it be punished, I guess is the question. Aristotle makes some distinction between what he calls a fully formed fetus and a non-fully formed fetus. He argues that a fully formed fetus, if it's aborted, could be punished potentially. There's also good reason to think that Aristotle is a marginal opinion. He's not expressing the mainstream point of view there. It's also true that occasionally you would see abortion punished if it countered the wishes of the father. The father wanted to keep the child, the mother decided to abort, therefore there could be a punishment potentially for the mother. Or abortion would be punished if the procedure resulted in the mother's death. So in those circumstances, you did see some punishments for abortion, but generally speaking, abortion was relatively commonly practiced, either chemically, physically, through other means. There's also evidence of early Christian and Jewish resistance to this practice. One commentator I read that said that exposure and abortion were widespread practices across the ancient world, with one exception, the Jewish people. And then, of course, Christianity grows out of that context. And I think that obviously that's critically important. We do have some early church literature that deals with abortion to some degree. The Didache, which is the teaching of the 12 apostles, sort of a guidebook for practical living, includes this quote, "Thou shalt not murder a child by abortion nor kill them when born." Again, a very countercultural message given the context in which this was happening. Now, we're going to fast forward, and much to my, my colleagues who are historians would just blanch at that fast forward. We go from the 300s to the 19th century. Not that anything happened between those periods, right? But we're trying to get close to Roe v. Wade. We don't have time to cover all of the history here. In the American and English, America springs out of English common law, so we have a lot of similar legal practices. In the 19th century, abortion laws focused on the concept of quickening. The concept of quickening. Quickening occurred when the mother could feel the fetus move within the womb. In the 19th century, laws against abortion after quickening were commonplace in America and in England. But of course, not laws that dealt with abortion before quickening, at least not to the same extent. In 1857, the American Medical Association begins a campaign to criminalize abortion. And they make the argument that quickening is a poor understanding of fetal development. After all, some women would never feel the child move and they would deliver a child. And so the difference between a child before quickening and after quickening, the AMA said, was not dramatic enough to say that we should treat them different criminally. And so the AMA starts a campaign, which again, if you know the AMA as it exists today, this is all remarkable, but the AMA starts a campaign to criminalize abortion. In 1861, in England, they passed the Offenses Against the Person Act, and that act creates punishments for women who procure an abortion and for those who procure abortions for women. So we're starting to see significant legislation put in place against the abortion procedure. In 1869, Pope Pius IX says that the human embryo has a soul and deserves protection as a result. So we start to see Roman Catholic doctrine orient around this understanding as well. By the time we get to the early 20th century, every state in the United States has significant legal protections in place for a fetus. I repeat that. By the time we get to 1910, every state has significant legal protections in place for a fetus. Regardless of the stages of pregnancy, they have protections in place. Feels like a different world, because it is. It is a different world. By the time we get to Roe v. Wade, we're starting to see changes happen. Starting in the 1950s, bearing more fruit in the 1960s, there is a movement against abortion laws. For those of you that know your history, or some of you that lived through that history, This is happening because of the sexual revolution. Women are questioning their roles in society. Sexuality is being treated differently. The pill has been invented and is being distributed and sold. And so now sexuality, the question is going to ultimately come down to, what about abortion itself? And so there begins a movement to liberalize abortion laws so that by the time we get to Roe v. Wade 1973, only 2/3 of American states now have significant legal protections in place for the fetus, regardless of the stage of pregnancy. So 1/3 of American states have liberalized their abortion laws by 1973. So when the court hears this case, they're looking at a country that's pretty heavily majority in favor of regulating abortion. Okay? So let's talk about Roe itself. In this case, the Texas law at issue forbids abortion except to save the mother's life. This is fairly typical for abortion laws at this point. This is being challenged, of course. In these kinds of legal conflicts, the state has to argue what is its purpose? What's it trying to accomplish through legislation? And Texas here articulates that it has two motivations, two interests in passing this legislation: to protect the mother's health and to protect fetal life. Texas argues that the mother's health is significant because abortion is a dangerous medical procedure, and the state should be able to protect the mother from that procedure. And that, of course, they have an interest in protecting fetal life. You know, they argue that the 14th Amendment includes a right to life, or the obligation of the state to protect life outside of due process, and therefore they say we should have an obligation to protect fetal life as part of that. The difficulty is that by the time the court hears Roe versus Wade, the court has already settled that there is a fundamental right to privacy. You know, this is an entire series of lectures in constitutional law. So I'm trying to squish it into a manageable package here. But the court in Griswold versus Connecticut, 1965, essentially says that there is a fundamental right to privacy that's implied by the Constitution. It's not directly expressed. There's no text to directly support this idea. But the right to privacy is fundamental and implied. In Griswold, the issue was contraception. Could Connecticut pass laws that limited the use of contraception? In Griswold, the court struck down the Connecticut law and said that it was a violation of this right to privacy, which was there to protect, and I want to be very careful with my language, intimate sexual conduct between married adults. That these relations, according to the court in Griswold, go beyond the reach of the state. And so this right to privacy is broad enough to strike down the Connecticut law. The question here, of course, is this right to privacy broad enough to include the decision to abort? It's a different question for the court. And so on the one hand, they're looking at privacy. On the other hand, they're looking at Texas' stated interest to protect health and to protect life. Justice Blackmun writes the opinion for the court. It's a 7-2 decision. And he makes some decisions, some assertions, some decisions here. The first one is that privacy is fundamental and that it includes abortion as a decision. So privacy has been expanded here to go from intimate sexual conduct to now we're looking at the consequence of that conduct, and we're talking about a physician and a lot of other things that are going on here. And so the court effectively says that privacy includes procreation, it includes familial relationships, and the woman's autonomy over these issues includes the right to an abortion. Now, whenever the court deals with what it calls a fundamental right, You can think of something like free speech or the free exercise of religion, which the court would also say are fundamental rights. That does not mean that the state has no business regulating them, because occasionally the state can step in and interfere with a fundamental right. Think of something like freedom of speech as an example. You have the right to freely speak, and that's protected by the Constitution. But that does not give you the right to stand on your desk in a public school classroom and yell obscenities at your teacher. In other words, the state can step in and encroach on your freedom of speech in certain times and places, and here's the key language, if the state has a compelling interest. So here the court has to decide, is the protection of health and life compelling? The court says no, or at least not in so many words, it is not. Why not? For health, it's primarily a question of statistics. The court reasons that abortion as a medical procedure is for the most part safer than delivering a child in terms of just mortality rates. And because of that, they say Texas' interest in protecting health is minimal until you get very late in the pregnancy. When it comes to protecting life, the court does, I use this word a lot, an interesting analysis. I'll just say this, it's an interesting analysis, flawed, troubling. It's an interesting analysis, though, where they determine, with a careful study of words like life and person and citizen in the Constitution, that none of those words were written to apply to a prenatal being. So when James Madison or when the framers of the Constitution sat down to write those words, when they used the word citizen, they weren't thinking of a fetus, the court says. Therefore, if Texas has an interest in protecting life, it can't really begin until we get to this critical moment of viability. Viability, of course, the ability of the fetus to survive outside of the womb with assistance. So the state has an interest, a compelling interest even in protecting life, but only at the point of viability, according to the court. Roe is it's a disturbing decision on a variety of levels. But with some sort of intellectual hand-waving at one point, the court says, we can't resolve the question of when life begins. Philosophers argue about this, theologians argue about this. Surely we as simple members of the court can't solve this question of when life starts. However, they say, this point of viability is when a legal interest begins. And so effectively, practically speaking, they are making a decision about when life is worth protecting, and for them it's at viability. Now, in order to sort of fit these things together, the state has an interest at some points of the pregnancy and life, and some points in health. The mother has a right to privacy. The court creates what we call the trimester framework. They divide the pregnancy into 3 phases, and they say the interests at work vary based on which phase of the pregnancy we're in. In this first trimester, the mother's right to privacy is dominant. The procedure is relatively safe. The fetus is not viable at this point. Therefore, the court says, the decision to abort in the first trimester is ultimately between the woman and her physician with really no state interference whatsoever. During the second trimester, health becomes more of a concern for the state to protect, so that the state can regulate abortion but not forbid it. So, for example, they could require additional licensing for a physician to perform a second trimester abortion, or they could require those procedures to happen in particular places compared to other procedures. They can regulate but not forbid. In the third trimester, the court says, when the fetus is viable and when the mother's health is most at risk, the state can indeed at this point prohibit abortion because its interests are now compelling. Now, the court requires, however, that exceptions be made, even in this third trimester, for the mother's life and for the mother's health. Now, I'm not a medical person. If any of you are medical people, you may sort of just be fearful of what I'm saying because I'm not speaking from a position of authority. But arguing about whether someone's life is in jeopardy seems relatively concrete, relatively. Arguing about whether someone's health is in jeopardy is a much more subjective process. And in Justice Blackmun's opinion in Roe, he uses some very particular language to describe the potential effect of denying an abortion to a woman. And this is the language that he uses. He says, specific and direct harm medically diagnosable may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm, he says, may be imminent. Mental and physical health may be taxed by child care. There's also the distress for all concerned associated with the unwanted child. And there's the problem of bringing a child into a family already unable psychologically and otherwise to care for it. What this means practically is that Justice Blackmun's talking about health as it's defined economically, socially, psychologically, not just simply physically. So practically speaking, if a woman can make a credible argument during the third trimester that her other dimensions of health are threatened, she could argue for an exception from any kind of prohibitions as well. So even though there's an argument here that third trimester abortions can be prevented, there's a pretty big loophole you can use to have them even in the third trimester. Well, obviously, there's a lot to criticize. And I'm just going to stick to sort of big picture criticisms here. Different things offend me because I teach constitutional law, so I probably function in a different way for a host of reasons. But what the court does here is effectively takes what is a political issue and makes it a constitutional right. So remember we talked about how a third of states had begun to change their laws. 2/3 of states had chosen not to. That means that elected officials and citizens and interest groups were all arguing about abortion and they were changing laws as a result. That's a political problem. However, when the court handed down this verdict, they effectively transformed the issue into one of constitutional right, removing the ability of the people and their elected officials to pass legislation about it. The troubling part of that, you could argue, well, Dr. Smith, that we do that already with things like free speech. Well, we do. But free speech is actually, in the text of the Constitution. There is no language defining a right to an abortion in the Constitution. There is no language defining a right to privacy in the Constitution. And so now the court is telling elected officials, you can't pass laws even though there's nothing specific textually preventing you from doing that in the Constitution itself. That's a problem. And I think ultimately it's an abuse of the court's power. I think you can also see, just based on my brief description, that the trimester framework is just pretty much garbage in terms of being scientifically arguable. Probably not more than 5 minutes after it was printed, the framework becomes technologically obsolete. Because think of the state's interests again. We have health and we have life. The mother's health, due to technology, is becoming less and less of an issue. Just bare bone facts. Abortion is becoming safer purely as a medical procedure because medical technology has advanced. However, viability is moving in the different direction. So viability moves toward conception, health moves in the opposite direction. All of a sudden, this trimester framework doesn't make any sense anymore. Blackmun, I think, ridiculously assumes that these things are static. Well, sure, we can divide it neatly into 3 phases, and this is how it works. Well, no, it doesn't work that way. Things change, and this becomes difficult to defend. You can also argue, of course, that Roe v. Wade is incoherent philosophically. We can get more into this if you want to have questions and answers about it, but effectively the court uses 2 different modes of interpretation, and it's just a real disaster, I think, just purely as a matter of law. So it's difficult to defend. So the consequences, of course, are that now abortion is widely available after Roe, up until the 3rd trimester. But just to be clear, the trimester framework says you can pass laws. It doesn't require states to pass laws. So if a state wants to regulate abortion in the third trimester, they can. But if they don't want to, they don't have to. And so the trimester framework doesn't really force states to do anything. But it says if you want to prevent abortion, here are the restrictions you have to operate under. It's also true after Roe that our political parties redefine themselves based on abortion to some extent. This may be shocking to those of you in the room, students, but it wasn't all that long ago that the Republican Party had a fair number of pro-choice Republicans in it, and the Democratic Party had a fair number of pro-life Democrats. That, within a couple of decades, became obsolete. So the political parties have defined themselves around abortion, understandably, I think, given the stakes of the issue according to both of their constituencies. But I think you can argue that abortion changed American political parties pretty dramatically. Abortion also distorted our judicial confirmation process, so that now when we talk about affirming judges for the Supreme Court or any other parts of the federal judiciary, the number one issue is really abortion in most cases, which means there are so many other issues that seemingly have slipped off the radar. And so we're trying to make sure that we appoint a certain kind of person, which is important, but in the end, you may not get all of the kind of person that you really want if you focus too much on one particular issue. Now, for those of you in the room that have some history behind you, these numbers may be surprising to you. Justice Antonin Scalia was confirmed by a 98-0 vote in the Senate. Justice Ruth Bader Ginsburg was confirmed by a 96-3 vote in the Senate. So we have a pretty radical pro-life justice and a pretty radical pro-choice justice, both overwhelmingly confirmed. Well, that would not be possible in today's world because we just look at the whole process dramatically differently. So as you would guess, judicial confirmations become an important way that we choose to elect senators, an important way that we choose to elect presidents after Roe versus Wade. What you see up there is a list of all the justices who are in the majority and the minority. So all the Roe justices are on the screen. The two at the bottom, Rehnquist and White, were dissenters. It's a remarkable turn of events. Republicans make the next 6 appointments to the Supreme Court after Roe. And they elevated a Chief Justice. And so 7 judicial decisions are made after Roe, and they're all made by Republican presidents. Gerald Ford gets an appointment in his brief tenure. Jimmy Carter gets 0 appointments. Ronald Reagan gets appointments. George Herbert Walker Bush gets appointments. And it looks like maybe things will change. So that by the time we get to 1992 and the Casey decision, all of those bolded names have been appointed by Republicans. Justice White still on the court. He was a dissenter in Roe. Justice Blackmun is still on the court. Justice Rehnquist is still on the court. Everyone else is new. If we just look at the numbers, it sure feels like the pro-life side should win this, 7-2, 8-1, right? This isn't much of a vote. And so there's this expectation as we got close to Casey that, you know what, the court's going to do it. They finally put the right people on the bench. They've done their homework, and so we're going to see something radically change. Well, that did not happen. So we don't need to go over all the particulars here, but Pennsylvania was trying to regulate abortion. They weren't trying to prevent it. They're just trying to regulate it a little bit. And the court has this opportunity to make a decision about Roe. So in determining whether Pennsylvania's laws are constitutional, the court is fully within its power to say, you know what, not only are they constitutional, but Roe is overturned in the process. Well, that's not at all what the court does. So the court, now these numbers are going to make probably a little sense to you because they seem to be all over the board. Well, it's a fractured opinion. It's a mess. If you read it, it's just all over the place. But effectively, the court here upholds Roe versus Wade. And in the process, four, but three key members who were appointed by Republican presidents surprisingly vote to uphold Roe. So Kennedy, O'Connor, and Souter, chosen by Reagan and Bush, thought to be pro-life to some extent, decide to join with the two liberal members of the court, Blackmun and Stevens, and uphold Roe versus Wade. Now, there were members of the court, of course, who were willing to overturn Roe at this point, but they didn't have enough votes. So, I mean, I can attest to this as someone who was aware and understood of what was happening at this point. This was a catastrophe. It was a shock to conservatives. It was a shock to Republicans who thought they had done everything right, and it turns out it just didn't matter. It just didn't matter. For our purposes, though, maybe what's most important is that in upholding Roe, the Casey decision also discarded the trimester framework. So we're no longer segmenting the pregnancy into 3 phases. We're no longer talking about these different interests at work. We're really asking just a basic question now at the court about abortion regulations. So in place of the trimester framework, the court institutes this undue burden standard. And it's described up there in the text. An undue burden exists according to the plurality opinion, and therefore a provision of the law is invalid if its purpose or effect is to place a substantial obstacle, that's the key language, in the path of a woman seeking an abortion before the fetus attains viability. So does the regulation present a substantial obstacle in the path of a woman before the fetus attains viability? So viability is still there, trimester framework's gone, and now we're asking this undue burden question. Just very quickly, typically things that restrict the number of abortion providers, things that, according to the court, unreasonably require licensure, those things are an undue burden, according to the court. And so the court has used this standard to maintain most of the outcomes of Roe, while still allowing some elements of regulation in some circumstances. Well, obviously, the court has changed again. So now, Casey's in 1992. Here we are in 2022. In 30 years, the court's changed radically. Only Justice Thomas is left on the court from the Casey decision. All these bolded names have also been appointed by Republican presidents. So Kavanaugh, Alito, Gorsuch, Barrett. Barrett, I have a star there because she replaced Ginsburg, and Ginsburg replaced White, so it isn't quite so clear. But again, we're looking at a position where there seems to be clear numbers on the side of the pro-life advocates. And so there's this expectation that things are going to change when the court hands down a decision in June. Well, if you've been paying attention, we have to be careful with expectations. We don't know what the court's going to do necessarily. So what is the court doing right now in the Dobbs case? I'll just briefly touch on a couple of things. It's always very speculative to listen to oral arguments and make decisions. Justices ask questions for a variety of reasons in oral arguments. It doesn't always reveal where they appear to be leaning in a case. However, with that caveat in place, it sure feels like, and based on their past decisions as well, Thomas and Alito are pretty willing to strike down Roe versus Wade. It also appears, I think, pretty obvious that Breyer and Sotomayor are going to uphold it. I think Kagan will as well, most likely, but I think Kagan may be open to compromise, perhaps. The swing votes are really Roberts, Gorsuch, Kavanaugh, and Barrett. Now, I think there's this expectation of what they're going to do based upon their past. You have to be very careful again with those expectations. It's a different world to talk about overturning Roe than signing your name to an opinion that overturns Roe. It's a different question. And the justices know that it's a different question. So the outcomes, as we talked about before, the court could overturn Roe and overturn Casey. The court could uphold Roe and uphold Casey. The court could try to split the difference. As I said before, my guess is the court will either overturn Roe or compromise. I don't think they're going to do just the status quo here, but I'm not willing to bet. That's for sure. When we think of the case, I just want to mention briefly some of the justices have particular concerns. And I understand, I would say I'm part of the conservative community. I think Roe should be overturned. But I think people need to understand why some of the justices are worried about the court's legitimacy. They're worried about the court's legitimacy. They're worried about the court getting involved in a controversial decision that creates cultural conflict. In their minds, the worst case scenario is a repeat of the aftermath of Brown versus the Board of Education. So Brown versus the Board, of course, the case that desegregates American education. Do you know how long it took for Brown versus the Board of Education to be meaningfully implemented in our country? It took 2 decades. It took until the early to mid 1970s for Brown versus the Board to truly meaningfully be implemented, which meant that the court handed down a historic decision and then the culture exploded and it made the court look weak, feckless, and unable to make hard choices. And the members of the court do not want to look that way. And so in their minds, they have to be worried. Remember, the Supreme Court does not have a police force. There's no army attached to the court. The court can make decisions, but it can't enforce them. And so they're worried about a decision that'll be difficult to enforce. Now, I think you can obviously argue this decision would be different. It doesn't enforce anything necessarily, but it gives states the freedom to pass laws. It would be different, but it would create a great deal of social unrest. And I don't think the court, many members of the court don't want to go down that road, particularly the Chief Justice. There's also the question of whether or not viability should be connected to this idea of the undue burden. And you listen to oral arguments, Chief Justice Roberts is clearly trying to get his colleagues to think about maybe we can disconnect the undue burden from this concept of viability and sort of move things around a little bit. Maybe we could let the Mississippi law stand, he's almost saying, and allow for abortion regulation up to 15, after 15 weeks without overturning Casey, without overturning Roe. The Chief Justice, I'm guessing, I could be wrong, I have no inside information, the Chief Justice has probably tried to put together a coalition of justices to do this very thing. This is where someone like Kagan, Breyer, and others may be open to this argument if they could at least get something out of the decision. So we'll see. There is also the concern about the right to privacy, broadly speaking. What if Roe goes? Does that mean Griswold goes? Does that mean the governments are going to start regulating contraception? Does that mean the end of the sexual revolution? Again, speaking very candidly, I don't care. To me, Griswold's a bad decision. I don't care. But the court is different, right? They're thinking of this in a bigger perspective. And so many of them are concerned about that issue as well. So this is a lot of information, but let's try to make it very practical here at the end. What can we do? What can we do? And of course, we're going to have more panels and more discussions, but what can we do, practically speaking, right now? The first thing that we can do is pray for justice. Let's make no bones about it. We should be praying for justice for the unborn. We should be praying that the court does what the court should do and overturn Roe and protect the unborn. Jeremiah 1:5, before I formed you in the womb, I knew you, and before you were born, I consecrated you. I appointed you a prophet to the nations. Psalm 139, for you formed my inward parts. You knitted me together in my mother's womb. I praise you, for I am fearfully and wonderfully made. We should pray for justice. We should pray for the protection of the unborn. We should end the 60 million plus abortions in our country. So we should pray for it. We should engage this issue. We should be politically active. We should be socially active. We should be culturally active on this issue. This is a no-brainer to me. So we should pray and pursue justice. At the same time, we should pray for the justices. It's easy to be critical of justices, especially if they disagree with us. But we need to understand, if we think that an unborn fetus is created in the image of God, so is a member of the Supreme Court. Right? They need to be prayed for. They need to be loved. They need wisdom. They need courage. Can you imagine the amount of pressure they're undergoing thinking through something that could be culturally revolutionary? Can you imagine being threatened physically with violence? Can you imagine your friends and family being threatened with violence if you rule the wrong way on an issue? This is the kind of decision where those things will come to pass. And so they're human beings. We should pray for them, that God will grant them the wisdom that they need, and that will grant them the protection that they need to make good choices. We should also at least try to understand where other people are coming from on this issue. You know, I think properly in our community, we see this as a clear issue of just protecting life, protecting vulnerable life. That's not how pro-choice advocates see it at all, obviously. Well, then how do they see it? Let me read from you an excerpt from Justice Ginsburg in an opinion, an abortion decision, Gonzalez versus Carhart. It's a dissenting opinion, but she puts it squarely. This is how she sees the issue of abortion. Women, it is now acknowledged, have the talent, capacity, and right to participate equally in the economic and social life of the nation. Their ability to realize their full potential is intimately connected to their ability to control their reproductive lives. Thus, legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course, and thus to enjoy equal citizenship stature. For Justice Ginsburg, the right to an abortion is what makes women equal in our society. For pro-choice advocates, anything that threatens abortion, in their mind, threatens their equality and is ultimately a form of oppression. You know, I don't find that argument persuasive. I'm not a woman. However, I just don't find the argument persuasive. But I think we need to understand how abortion is central to that view of the world, so that if it's endangered, what kind of response they're going to have. We have to understand that to have fruitful conversation and fruitful discussions. So be willing to wrestle with where they're coming from, that's going to be radically different from where you're coming from. And then, of course, we need to consider life after Roe. We should consider what the world could look like for a few months after June. We should consider what kind of laws we want to pressure our elected officials to pass if they overturn Roe. We should consider how we're going to love our neighbors after this decision. We should consider how we're going to speak into the culture after this decision. You know, this is ultimately what motivated us to create this series, because we feel strongly that our students, our faculty, our staff, our constituents, our alums, that everyone should start to think hard about this before it comes to pass. Again, we have no way of knowing what could happen in June, but we better be prepared for all the different scenarios. Thank you.
Hi. Thank you. We're going to start our Q&A, but before then, my name is Haley. I am the Vice President of Students for Life work here on campus. And I just want to let you know an event we're having Wednesday, so tomorrow at 7, we'll be having Dave Right to Life come to speak to us in the HSC 105. They will be discussing in the upcoming Supreme Court cases regarding abortion, how they are working to shut the abortion clinic down in Dayton that we do our prayer drills at. So come there, it's Wednesday at 7 at HSC 105. And now we're going to start the Q&A.
I just got a question if Roe vs. Wade does get overturned, would that also affect the birth control industry? Because there are some birth controls that have abortive-like effects. Would they also die out too, along with abortion, if they were to get overturned?
Yeah, it's a good question. So if the court overturns Roe, will that affect pharmacology and other approaches to abortifacients, for example? I think that it certainly would. It would give states the ability to regulate those things if the states choose to regulate them. It would also, of course, give states the ability to leave them alone if they choose to leave them alone. So, if Roe gets overturned, I fully expect California and New York to have very liberal abortion regimes where you can have abortion on demand through whatever form you want, pretty much all the way up until birth. However, a lot of other states are going to have a lot more stringent regulations. There's going to be an awful lot of variety about those, I would think, including potential abortifacients. It's a good question.
After Roe, why do you think the political parties took the positions that they did? Because if I lived before Roe, I think the other party would probably take that position.
So ultimately, why did the Republicans shift toward a more pro-life perspective, and why did Democrats shift toward a more pro-choice perspective? I think the simplest answer is they both had constituencies that were developing hard positions on the issue. So the Democratic Party had already been working fairly closely, for example, with the feminist movement. They're sponsoring the Equal Rights Amendment and other things. This becomes, I think, a natural extension of that as a way to sort of begin to work with that constituency and to secure support. The Republican Party at this point is already beginning to think about transformation in the South and how do you attract Southern voters that are religiously conservative. Abortion is a pretty good issue to start to do that with. And so I think that it fit in fairly easily with their emerging constituencies to the point where the parties, practically speaking, probably did not have much of an option but to go the ways that they did, just in terms of pure politics.
Thank you for taking the time to talk to us today. As you said, Casey's undue burden standard affects our current abortion jurisprudence more than does Roe. Roe, for its part, has to some degree been relegated to a flashpoint in our current culture war. Would pro-life advocates not better preserve our testimony by focusing on gutting the court's precedent that affects abortion rights today, and thereby avoid what Justice Sotomayor described as the stench that this would create in the public?
So I just want to be clear, are you suggesting then that pro-life advocates could focus on the undue burden standard and leave Roe alone? Is that what you're sort of getting at? I want to make sure. Even though the court discarded the trimester framework in Roe, Casey very much affirms what it calls the central holding of Roe versus Wade, which is ultimately the woman's right to choose an abortion before viability, according to the court. And so I don't think you can easily attack Casey without ultimately going after Roe as the foundation for Casey. Now, I do think that Chief Justice Roberts is a very clever man. He's a very, very gifted thinker. And I'm sure that he would like to figure out a good way, as we talked about, to sort of split the difference there. But I just don't know if that's really practical, honestly. Just purely as a matter of constitutional law. I don't know if it's practical. But on top of that, now I think what you could be saying, and I think there's some, I mean, my guess is, honestly, that the court is going to probably slowly nibble away at Roe through several decisions over a period of years, as opposed to just radically overturning it in one step, right? And so I think you could ultimately kind of see your argument coming to fruition if the court figures out ways to sort of, just sort of almost death by 1,000 cuts, right? So to the point where over 5 to 10 years, Roe becomes basically no law at all through a succession of decisions. I think if more moderate members of the court had their way, that's what would happen. I just don't know if they're going to get enough support from people who are on the right or the left to take that route.
My question is, how would you say we pursue policies that are still pro-life, but also, I guess, show compassion for women who might be struggling with health problems that involve maybe a child that they know is not going to live long enough to be carried to term, and
Right.
how do we kind of, I guess, mesh it without being too harsh, but too soft.
So, is it possible to be harsh, to avoid being harsh? I mean, I'll just tell a quick story, right? So I was at a conference, I was invited as kind of the token evangelical to a conference. So I had a friend who was at an organization who said, I need someone to come and represent the evangelical point of view. Are you willing to do that? It was an unusual conference where you were expected to come and talk about a topic for 10 to 15 minutes on a panel of people who had diametrically opposed opinions, and then they would discuss afterwards as a group sort of how they saw each other's point of view and try to have a meaningful dialogue. We got to the issue of abortion on one of those panels, and I was the only panelist to argue for a pretty strongly pro-life position. And we eventually started to talk, what could we possibly agree on? Like, where could we find some common ground of agreement where we could pursue policies that we would both be supportive of to some degree or another? And I think that's an important question. And I think it's actually the question we need to be asking in these kinds of conversations. We can't always expect the other side to just give up its most fundamental, cherished right, necessarily, just like we would not give up our most fundamental, cherished right. We have to think, are there ways that we can build bridges to get things done in a policy sense, even though we have strongly held differing opinions? So we had conversations about, should we have policies in place that protect, that give women funding, for example, when they're carrying a child? Should that be publicly funded? Should we provide health care to women so if they're pregnant, we take care of everything? Right? We want to make sure that you carry that child to term. We'll make sure that you don't incur any expenses. I understand that creates all sorts of other issues, and I get that it doesn't make it comfortable for ideological categories. But I mean, you have to start to have those kinds of discussions to figure out, can we sort of make some sense of this? And so I think you have to start down that road first. But I have to, we have to be honest about it. There's certainly a significant segment of our society that's just going to resist our argument regardless. And at that point, I'm okay with that. I'm okay with that. I think if we present ourselves well, if we do our best to argue with good faith, present the truth in love, if we do our best to show love to those folks, even though we vehemently disagree with them, I'm okay with that, right? Even if we have to walk away and say at the end of the day, we just don't share enough in common to work together, that's okay. So I appreciate where you're coming from, and I think it's important to get into those discussions if we can, but I don't think we need to be naive to think that those discussions are going to solve fundamental disagreements.
Going back to what you were saying about how California and New York will most likely have very liberal policies.
Right.
Do you think that there will be a serious and maybe potentially damaging conflict between states, especially in cases of people going state to state.
Yeah.
And do you think there's any way that the court might be able to avoid that?
So, what state was it? Just in the last few days, they're considering a piece of legislation that would allow citizens to sue if another citizen goes out of state to have an abortion and then comes back to the state. Was it Missouri? Yeah. So yeah, the short answer to your question is yes. I expect it to get quite contentious in those kinds of questions. It brings to mind, of course, the Texas law where they've tried to restrict abortion by allowing private citizens to bring lawsuits to people who've helped procure an abortion. Again, I want to make it very clear. You know, we should want to eliminate abortion, but we have to understand that that's a really hard path to go down, which would jeopardize all sorts of other rights that we have. So if we're going to allow private citizens to bring lawsuits in a situation like that, well, guess what? California is going to pass the same law that allows private citizens to bring lawsuits against someone who buys a gun from out of state. So we're going to see it trickle into all these other things, and it will empower states to be very restrictive on rights and liberties in ways that I don't think we're quite anticipating. So yeah, I think that you're right. You probably will see some contention between states as they try to regulate. My guess, though, is the court is going to at some point have to step in and put very real boundaries on what states might be able to do in those kinds of situations. I just don't think they're going to be able to avoid it for long. It's a good question.
So with regard to the fear that the court would appear illegitimate if it's unable to uphold, if it's unable to enforce a decision, isn't that an illegitimate fear given that constitutionally the responsibility of the executive branch is the enforcement of law and the court has no obligation to do so?
Well, at its root, sure, the court is empowered to enforce the law. The executive is empowered to enforce the law. True. However, you know, again, go back to our history of Brown versus the Board of Education. You didn't see a lot of executive enforcement of those laws, right? You do see Eisenhower doing some enforcement in some places. You do see Kennedy doing a little enforcement in some places as well. But they certainly weren't doing things like calling out all of the military to go and occupy the South to enforce the law, which is what they would have had to have done, probably. So yes, I mean, you're right that at some level it's the executive's responsibility. But it's also true the Supreme Court does not have a mechanism in place to really force the executive to do that. And so both of those branches, to one degree or another, have to coexist. And that's where the court's legitimacy gets really difficult. If the court gets too far ahead of the legislature and the executive, it makes the court vulnerable like it was after Brown. If Congress gets too far ahead and the court is willing to restrain it, that makes Congress problematic as well. And so all these things are having to function to some degree in some sort of harmony. But the court is in, you know, as the Federalist Papers famously say, the court has neither the power of the purse nor the sword. They're in a vulnerable position when it comes to the other branches of government. It's a really good question.
Dr. Smith, thanks for putting this on. My question has to do with judicial activism and the role that the courts play in essentially making legislation.
Sure.
How do you think the outcome of this case will affect the broader issue?
Yeah, that's a great question. So I think when you go back and look at the trimester framework, the trimester framework doesn't look like a court decision, it looks like a law. So it looks like legislation that a Congress would pass in order to construct an approach to regulating abortion. And so I think it's a good example. Roe is a good example of something that looks closer to judicial legislation than it looks like a coherent judicial decision. Again, to some degree, judicial activism is in the eye of the beholder. You know, certainly progressives would look at some conservative court decisions and say, well, that's activism. Conservatives will look at some progressive decisions and say, well, that's activism. Again, you know, I'm conservative, you know, so I see when a court renders a verdict in a way that's difficult to pin to a particular constitutional text. When the court asserts a power that it doesn't obviously have or restricts states from engaging in powers that they obviously should have, then I think you really are starting to look at judicial activism. You could argue, I think, on some decisions that conservative courts have made that maybe get close to judicial activism. You know, I'm thinking of the Alabama case where the court looked at the Voting Rights Act and basically stripped out a section of the Voting Rights Act and said that it doesn't quite fit with where we are now. Congress has to start over. Even though I think that's a matter of good policy, I'm not sure it's probably activistic for the court to do that. And so the Shelby case. So yeah, I mean, I'm concerned about judicial activism. Now, if the court made a decision to overturn Roe, see, I would see that as the court actually pulling back on what was a very activist decision. So I see that as a healthy decision for the court to make. But of course, the progressives would not. It's a good question. There's one over there.
So jumping back a few questions about conflict between states. If Roe v. Wade were to be overturned and say a state were to try and regulate abortion by saying that people couldn't go like across state lines to have an abortion, could the Supreme Court regulate that with the Interstate Commerce Clause?
I deserve that. Yeah, I deserve that. So for those of you who've taken powers in federalism, you know that the Commerce Clause is like half of that class, and we spend more time talking about the Commerce Clause than anything else. So I appreciate that. There is no question, Rachel, as you know, that the Commerce Clause would be brought to bear in that argument. And if states tried to prevent economic transactions from across state lines, I think the court would be able to step in and say you don't have the power to prevent people from engaging in commerce across state lines. So yes, correct. It's very good. All right, one more, if there's another one. Two more. We'll let Johnny ask his question.
What do you think the international impact would be if Roe is overturned?
So it would depend on exactly how we were to overturn it. I'm not as up to speed on abortion law in the European Union, for example. I know a little bit about it. From what I know, our abortion laws tend to be more progressive even than their abortion laws on the whole. They allow for abortion, but they restrict it much sooner in the pregnancy than what we do in general. So to the extent that you overturn Roe and allow states to restrict it entirely, it would certainly be different than what you see in Europe for the most part. But I don't know if it would really affect our image meaningfully, because I think most of Europe already sees us as, gun-toting, Christian, we're just odd to them, right? And if you've ever been to Europe, you understand why. Just two different worlds, right? And so I'm not sure it would have a dramatic effect, honestly, because I don't think that it would do much to counter the stereotype they already have of who we are.
So you talked about how Roe changed the confirmation process for justices, the Ginsburg rule, how people don't, they get asked about their stance on abortion and people are able to say they won't talk about it. Honestly, Judge Brown's confirmation is happening right now. It's quite possible that the makeup of the court changes over the next 10 years. What does it look like if Roe doesn't get substantially changed for the next 10 years, if the court changes or doesn't change for the future of abortion laws, federally, but also at the state level?
I think that if the court right now sort of doesn't approach this question and make significant changes to Roe, I think you're likely to see status quo for a while. I didn't talk about it in the presentation, but members of the court, and this is true for Breyer, it's true for Roberts, it's true for Thomas, they've all been talking publicly recently about their fear of court packing. They've all been talking publicly, which is unusual for them. They're talking about how they don't want to be packed as a court, they don't want to be politicized as a court, and so they're trying to warn the Senate away from going down that path, especially getting rid of the filibuster in the process. So I think, I mean, my fear would be, and again, it would be worth doing, but my fear would be if the court overturns Roe, you'd see a significant movement to pressure the Senate to discard the filibuster and to pack the court. Now, Senator Manchin, Senator Sinema both said they won't do that. The world will look pretty different if the court actually follows through on that. So I think you could see a lot of pressure. So I think you'd potentially see some effort to change the court, depending on what the court does in June, whether that'd be successful or not. But you know, these things are tough to predict. It's hard to predict who's going to win the presidential election in 2024. It's hard to predict who's going to be in the majority in the Senate in 2024. And so, it's not Donald Trump had 3 court appointments in 4 years, which is remarkable, right? Jimmy Carter had 0 in 4 years. And so these things don't always work in a very easy, predictable way. So it could be within 10 years, the court will look dramatically different. We just don't know. It's a good question. All right, thank you very much. I appreciate you for coming.